This morning's topic is legal updates. Jim?
Thank you. Good morning, everyone. Good to see all of you. Over the years, I've now been representing the association here for, I think, 12 years. And I've made a lot of friends during that period of time. And as many of you know, I grew up in San Diego. So coming back here always feels like I'm coming home. There is a lot of stuff that is going on in terms of new changes in the law, most of which is effective January of this year. And I'm not going to be able to cover everything that's happening, but I've selected quite a few of the more important things I think we should talk about. And hopefully there's something for everybody that either helps make you some money or helps keep you out of trouble. Most of what we're going to be talking about are changes in California state law, but there is one development on the federal side that I want to talk about. The Treasury Department for some time has a financial crimes enforcement network that's been targeting financial crimes, mostly money laundering, things like that, but there probably are some other things they're looking at as well. And for some time now, they have had a requirement in place that any residential transaction that closes where the buyer is an LLC or a corporation, the individual owners behind that entity have to be disclosed by the title insurance company to the Treasury Department. I'm not exactly sure how that reporting process works or what the Treasury Department does with it. I imagine initially they just compile statistics and look at things. But the change in the law, that's been going on for a while, but the change in the law effective January of this year is that the threshold came way, way down. It used to be, it was either 3 million or 5 million was the threshold mark where reporting had to occur. Now it's down to a transaction involving cash of 300,000. And that's almost any transaction basically involving real estate in Los Angeles County. This doesn't apply everywhere in the country, and in California they've got five or six counties they've targeted. Unfortunately, one of them is Los Angeles, so this is going to affect some of your transactions. And the reason it's important to keep in mind is if you've got a client who is concerned about confidentiality or has some problems in their past or their current working environment where they don't want to have things disclosed, you'd probably be doing them a service to let them know that this program is in effect and that they're buying something through an entity, a residential property involving a relatively small amount of cash. It is going to be reported to the Treasury Department. So just keep that in mind. The big thing in terms of state law is a real estate cleanup law. As most of you know, the real estate law in California is codified in the Business and Professions Code starting at section 10,000 going on, and it encompasses hundreds of statutes. And over time, what happens with a big body of law like that is it gradually gets out of focus. Little discrepancies occur, changes occur that aren't correctly reflected in the law, things like that. I believe the California Association of Realtors sponsored this law, and basically what it does, it updates and cleans up a lot of little glitches in the real estate law, in the Business and Professions Code. And most of the changes aren't substantive in the sense that it really hasn't created any brand new duties to speak of, but there's just a lot of little glitches that have been cleaned up and a lot of tweaks that have been done to hopefully simplify the law, make things a little bit easier to abide by. And one of the first things this set of laws does, it reaffirms that salespersons and brokers can establish their relationship as one of either independent contractor or employee. That distinction is still significant. The lines between independent contractor and employee are blurring to some extent in some areas of the law. And as has always been the case, whether you're an employee or an independent contractor as an agent really doesn't matter in terms of the regulatory environment, how the Department of Real Estate sees you or enforces its rules, or what happens to you in civil litigation. Whether you're an independent contractor or an employee of your broker is still on the hook for what you do in terms of licensed activities. There are still significant differences, though, for employees in terms of income taxes, obviously, because the IRS many, many years ago cut a deal where they backed off on their claims that you as independent contractors should be treated as employees for federal tax withholding purposes. And it's also still a significant distinction in terms of many of the employment laws, like overtime laws, leaves of absences, that type of thing. Many of those laws that apply to employees don't apply to independent contractors. So it's still an important distinction. But anyway, this kind of an update to the law is almost, if any of you are into computers, you know, periodically you get changes coming through, updates to your system, whatever version of Windows you got. It's usually little tweaks and little patches. And then every now and then, every 2 or 3 years comes along a major update, and it becomes a service pack, and that goes out. This is kind of like a service pack. Every year we have a few little tweaks here and there. This is a whole bunch of changes to the real estate law. The next thing this update does, it clarifies that the responsible broker has a duty to supervise salespersons and broker associates, regardless of whether they're employees or independent contractors. That's not exactly a news flash. That's existing law, but now it's clarified and it's actually put into a statute. One good thing this set of new laws does is it cleans up a lot of the terminology. It gets rid of a lot of the confusing references, like, for example, calling a buyer's agent a selling agent, which seems to be kind of confusing because you would think a selling agent, that almost sounds like they should be representing the seller. So they've gotten rid of a lot of the problems and they've kind of cleaned up discrepancies. So they've basically now, in terms of salesperson and broker, the relationship, they got rid of the word employee and employee, which really concerned a lot of people. They now use the terms retain or retention. There we go. They set up a whole new definition section in the real estate law. Previously, a lot of definitions just kind of came about gradually as laws were changed, and you'd have to go through, and to pick out the way terms were defined, you'd have to go through the entire real estate law sometimes to find them. They've created a more all-encompassing section right up at front that has definitions in it, which is going to be useful. And as I mentioned a minute ago, they got rid of some of the confusing things. Now it's seller instead of transferor, buyer instead of transferee, so they've kind of gone more to a plain language type of system. And selling agent, buyers, selling agent is no longer selling agent, it's now buyer's agent, so we don't have that confusion. There are some significant differences in the way dual agency disclosures are handled, and probably any of you who have done a deal since the first of the year and work with the new CAR forms have seen the new form language, both in the RPA and the individual disclosures. They got rid of the third agency disclosure. So buyer makes a disclosure to the buyer's client, seller makes an agency disclosure to the seller. There's no longer a requirement that a buyer's agent presenting an offer to a seller has to deliver a third agency disclosure to that seller. That's gone. One important thing that will hopefully help keep some of us out of trouble more readily with dual agency transactions is that, as all of you know, the existing dual agency law had a kind of a safe harbor in there, a protection for you guys that when you're acting as a dual agent, even though you have fiduciary duties to both buyer and seller, there was a limit on those duties. You didn't have to disclose to a seller what your buyer was actually willing to pay for a property. And similarly, you wouldn't have to disclose to your buyer what a seller was willing to take for the property. But up until this year, that was pretty much the only limitation that was placed on that. They've now broadened the scope of that protection for you guys, and now it's expanded so that you don't have to disclose facts relating to things much more than just price. Anything relating to financial position, motivations, bargaining position, or other personal information that might impact price, you have a right to keep that separate and not disclose it to your other client. Having said all that, keep in mind that dual agency transactions, as economically valuable as they are still the most dangerous transactions out there for you guys. Most of the cases I defend brokers in are dual agency transactions, and just about all of the really nasty cases are dual agency transactions. Because even though you've got some protections built into the law now that help you, there are just difficult questions that can't very well be answered by a dual agent in many situations. And those, just my advice would be to approach those transactions with care and really be cautious when you're in a dual agency transaction. One additional kind of a glitch that they fixed up. As you know, a few years ago, 2 or 3 years ago now, it might have been more than that, the requirement of agency disclosures was extended to commercial and industrial property and raw land. But what they left out at that time was residential property that was 5 or more units. So up until January of this year, the agency disclosure requirements existed for 1 to 4 residential units and almost all non-residential property, but for some reason it didn't apply to small to medium to large apartment buildings, 5+ residential units. They got rid of that, so now you've got to give an agency disclosure even for a 500-unit apartment complex. Most of you, I imagine, by now have seen the new agency disclosure language. You've got the broker's name, space for the broker's DRE number, then you got space for the name of the agent and the agent's DRE number, both for the buyer and the seller. So it's a pretty comprehensive set of information explaining who's representing who. Should be a lot easier for somebody to understand who's not in the business and one of your buyers or sellers looking at it. My understanding is that ZIP Forms has some safeguards built in where it's almost impossible to screw up filling those things out. So what you don't want to have in this situation, you don't want to have a broker saying he's representing the seller and then his agent coming along and claiming that he or she represents the buyer. That can't occur. And I understand that with ZIP Forms it doesn't let you do that. If it has some logic built into it, it'll stop that from happening. But if occasionally you're presented with a hard copy form from somebody, keep in mind you still have to be careful to make sure those things are properly filled out. Some terminology has changed also. Instead of representing both buyer and seller, now it's just you're a dual agent is the terminology that's used. Broker associate, we've had that term in use for decades, but it's never been defined in the real estate NAP law. Now it is a defined term. The law clarifies now that the responsible broker has a duty to supervise and oversee licensed acts regardless of independent contractor or employee status, as I mentioned previously. There is an express provision now stating that salespersons can enter into contracts with each other to share compensation so long as any compensation is paid through the responsible broker. And another important change that makes things a little bit more convenient for you guys is that previously a listing agreement had to be delivered, a copy of it had to be delivered as soon as it was signed. That's difficult if you're dealing with digital signatures and transmission electronically. So the law's been tweaked a little bit now to provide that a copy of the listing agreement can now be provided as soon as reasonably practicable after the listing signed. So you got a little bit of room to work with there before you're in violation of anything. When I first got into this business 30-some-odd years ago, there was a requirement that brokers kept physical possession of the salesperson's licenses, the salespersons who worked with them. That's finally been eliminated. Brokers don't have to do that anymore. Brokers also don't have to interlineate the salesperson's physical license when there's a change in responsible broker. Another little change is that you are no longer required to notify your buyers of their right to receive a copy of the appraisal of their property. So there has been some confusion over the years about the application of the transfer disclosure statement requirements to trusts, and that's been cleaned up in this new law. It's pretty clear now in almost all situations that where you're dealing with a revocable living trust, which is the kind of trust you're going to see 99 times out of 100 out there working in the field, in almost all those situations you're going to have to comply with the transfer disclosure statement requirements. Basically the law says that if the trustee is a natural person, it was either a former owner of the property or he now occupies the property, that disclosure has to be given. And that's almost every situation, because the typical situation where a family has a trust as their estate planning vehicle, usually the people that create the trust own the property before. As soon as the trust is created, they transfer the property to the trust and they continue to reside there. So all these triggering events occur. The law also now allows officially for electronic delivery not only of the TDS but also the natural hazards disclosure. So that's a slight little change. One additional change having to do with the transfer disclosure statement has to do with when the buyer's rights to rescind become effective. And the law has clarified that now all 3 sections of the transfer disclosure statement have to be completed before the time clock starts ticking on a buyer to exercise his rescission rights. So you can't give a buyer a half-completed transfer disclosure statement and expect that to start their time clock ticking to get out of the deal if they want to do that. It's not until they receive a completed copy with all the information in it that they have their time to start to consider canceling starts to run. And the same cancellation and delivery rules that apply to the transfer disclosure statement also apply to the natural hazards disclosure. You know, and here's every time I do one of these things, usually the morning of, I'm looking at what I did and I realize I got a major typo, and then here it is in this one. Where it says the cleanup legislation does affect any of the following. What that should say is the cleanup legislation does not affect any of the following. And it really doesn't change the basic substance of existing law about brokers' duties between broker and salesperson, and the fiduciary duties owed by a broker to the person who hires the broker. Any disclosure that might be required under existing law continues on. Any duties owed by salespersons and broker associates to their responsible broker, and the responsible broker's duty of supervision over salespersons and associate brokers working with that broker. So none of that stuff, none of the substance of that has changed. It's just the way things occur and how things are documented and how the compliance has to work that's been tweaked. Okay, moving on from that, that's all a mouthful, and that's not even all of it. If you have a chance to go through and look at it, you can pull it off the CAR website. They got detailed discussions of this new cleanup to the law too. There's a bunch of other things that have happened, mostly effective at the beginning of this year. I don't know how many of you run across private transfer fees on transactions you handled. That's a situation where a builder or developer imposes a covenant that runs with the land on a house they sell, and it requires that if that house transfers maybe several years down the road, guess what? A fee is payable back to the developer who built the home. And wasn't anything really illegal about that previously, but now the ability of a developer and builder to stick that kind of a post-closing tax on their developments has been sharply curtailed. It's only allowed now when it confers a direct benefit to the property. So I was trying to think through a situation where you might have such a benefit. One thing I could think of is if you've got a gate-guarded community, for example, and one of the ways the developer came up to finance that ongoing service is that whenever a property transfers, a fee gets paid. Something like that, you could argue that provides a direct benefit to the property. Most situations, though, where it's just additional profit going into the developer's pockets, that's no longer allowed. It doesn't invalidate existing private transfer fees, but from this point moving forward, you can't have new projects with those. A couple changes in building permit laws. Existing law for many years was that you had to begin construction within 6 months after pulling a building permit or it would lapse unless you were able to renew it under some provision. That's been doubled now. Now you have a full 12 months to get going, to break ground before your permit goes stale. And you can also request additional 180-day extensions if you make those requests in writing and quote-unquote justifiable cause is shown. That's going to be determined at the agency level at various cities and counties. Another law, I don't know how in the heck this is going to work in practice. I suspect not very well, but all of us have had the problem of running across improvements to a piece of property that have not been properly permitted, or that there's no good documentation of the issuance of permits. And this new law basically requires cities and counties to adopt a building standard that allows permits to be issued retroactively according to whatever building standards were in effect at the date of construction. And then they're required to issue a retroactive building permit when a record of the issuance of the building permit doesn't exist. That sounds real good, but I suspect the red tape involved in that is going to be absolutely horrendous. And trying to get this system to work during the course of a typical listing or a transaction, I don't think it's going to happen in time with most cities and counties. Because you're going to ask the building official to go back and figure out what code standards were in effect possibly 50 or 60, 70 years ago, and then to determine if those standards are met in the apparently unpermitted improvement. But anyway, it's out there, so keep in mind if you run across a situation with a missing permit, you may be able to use this law to your advantage. As real estate agents, you guys have been potentially liable for sexual harassment for some time now. None of us escape that. They're really getting after lawyers like crazy too. Effective at the beginning of this year, there's basically a hands-off policy where lawyers can't do anything sexual with their clients regardless of the circumstances. Not because they're gaining an unfair advantage or anything else, it's just absolutely prohibited. They're also requiring lawyers to get re-fingerprinted now by April of this year. I think the state bar thinks they're going to catch a lot of lawyers who haven't been self-reporting various problems they've had with the law and what have you. But anyway, so you guys, for a while now, you guys have been potentially liable for sexual harassment. If you hit on a client or something and they don't like it, that could be a problem for you. What this law changes, it's basically an expansion of that existing law. Now you guys can potentially be liable for sexual harassment of a potential client. So it doesn't have to be a situation where the relationship already exists. You know, it's not somebody whose property you've already listed. It's anybody you run into that you might want to do business with as a real estate agent. The part of this law I don't understand, it also extends to investors. I'm trying to figure out how an investor would sexually harass somebody. I kind of have a vision maybe of some guy in a raincoat writing offers on income property or something, but beyond that it's kind of hard to understand how that would work. But anyway, keep in mind the political correctness policies that are sweeping around the country are continuing to develop and expand, and you got to be careful out there. Also on the topic of sexual harassment, up until this year, there was a requirement that any employer who employed 50 or more employees had to provide certain training regarding sexual harassment to its supervisors. That didn't affect most of us, you know, unless you have a really big company. You're not going to have 50 or more employees in this business typically. This new law drastically changes that threshold. Now it's down to 5 or more employees. And that includes independent contractors. So almost any more than really small brokerage firm is going to be subject to these requirements. And you have to provide at least 2 hours of training to all supervisory employees, like brokers, office managers, that type of thing, and at least 1 hour of sexual harassment training to all non-supervisory employees by January of next year. So you've got a little bit of lead time on this, and then once every 2 years thereafter. And the Department of Fair Employment and Housing, which governs not only fair housing but also all employment issues in the state, is required to post 1 and 2 hour courses online. I haven't looked yet to see if those are posted. I think they are still in the development stage, but that might be an easy way to comply with this. So you might watch out for that as it goes on. Foreign language loan disclosures. The law has been that certain loan disclosures have to be provided in the same language the loan was negotiated in. That's been expanded and changed just a little bit. Now they're required when the loan is modified also. And it doesn't apply to every possible language out there, but it's got a handful of them that are the more common languages you might run across, particularly in this community. So keep in mind if you do any work with loans. And that's financial institutions, so it wouldn't apply to single occasional loans being done by one of you or seller financing, that type of thing. And then the existing law is updated so that it clearly applies to loan estimate and closing disclosure forms, not just the good faith estimate. There's 8 new laws having to do with the response to all the wildfire problems we've had in the state. Mostly cracking down on insurance companies and trying to keep them from taking undue advantage of people who have been harmed by this situation. Insurers can't cancel or refuse to renew a homeowner's policy for 1 year from the date a declaration of emergency is declared. For survivors of major disasters, the insurer must renew a residential policy for at least 2 12-month renewal periods and grant 12 months additional living expenses. Insurers must cover losses resulting from combination of disasters if an insured disaster is the cause of the loss and would otherwise be covered. That happened, the reason they did that is that there are a lot of exclusions in policies. If you go home and look at your homeowner's policy, it's going to have a basic declaration of your insurance coverage. Then the next 50 or 60 pages are basically going to be a series of exclusions and situations where you don't have coverage. It might be you're not covered for floods, you're not covered for earthquakes, you're not covered for all kinds of things. And one of the tricks of the insurance companies was that if they could pin the blame for any damage to your property on one of these non-covered areas, they would say, well, you're not covered for that. This says no, if there's any cause, any possible cause, if there's multiple causes and any one of those causes is an insured event, you have coverage. The period of time for full replacement benefits under a replacement cost policy has been expanded from 24 months to 36 months. An insurer can't limit or deny payment because a policyholder is elected to rebuild or buy something new in another area. They can't require you to stay in the same plot of land you were on that your house burned down in. Statute of limitations is doubled from 12 months to 24 months for any losses related to a state of emergency. And then there's a requirement that the insurance commissioner convene a working group to come up with new insurance products. And another new law that's supposed to connect consumers with insurance agents and brokers. I thought that was called the marketplace, but I guess they envision something more formal, maybe something like the healthcare with Covered California or something. So we'll probably hear more about that over the next year or two. For those of you who manage property or own rental property, there's a few new laws affecting landlord-tenant relationships. One of them has to do with property that's abandoned in a commercial place of business or commercial property. One of the things I don't do a lot of eviction work, but I handle some of the bigger stuff for some of my clients, and frequently we run into situations where we finally get somebody out and there's a bunch of stuff left behind, and what do you do with it? And there's a whole bunch of laws that have been on the books for quite a while that allow you to give notice of your belief that the property's been abandoned, and then there are certain things, depending on the amount of money involved, certain things you have to do after that to safeguard yourself and protect the property. The change in the law here is that the notice of belief of abandonment can be given based on a non-payment of rent after a very short term, in most cases 3 days. It's whatever the period of time is that would allow you to give a notice to quit if the rent isn't paid. So previously you had to wait 14, if you were using non-payment of rent as the basis for your belief that property had been abandoned, you had to allow 14 days before you could do that. So I've got a situation, I just finally successfully evicted a pot shop, which is just about impossible to do because those people are incredibly well funded and incredibly well financed, and they know all the tricks. We finally just got the property back, and for about the last 2 weeks I was wondering, what do I do? Obviously they moved on, they moved out. They said they moved out, but they still got a lock on the door, and we don't have the key. And so there's a lot of problems with engaging in self-help as a landlord. So we still had to sit back, be patient. Finally, we got confirmation they're out. And the same thing with regard to disposal of personal property left behind. There is a safe harbor if mostly what's left behind is a bunch of junk, and you're pretty confident that's the case. You can go ahead and dispose of it and not worry about it. The threshold has expanded, so the landlord is much better protected than they were before. The existing law up until the end of last year was that anything where you had a reasonable belief that the property is worth less than $750 or $1 per square foot, you can go ahead and toss it. That's been increased substantially to $2,500 or 1 month's rent. So like in the situation I've got where we just recovered possession, there's a whole bunch of trash in the property. Obviously doesn't have a whole lot of value, so we can just go ahead and dump it. We don't have to give notice of their right to reclaim their trash. Electric vehicle charging stations. This is kind of a goofy law. I don't know how this happened, but existing law was that landlords had to provide an electrical vehicle charging station for a tenant that had an assigned space, as long as their reasonable rules and regulations were followed. But there was an exception. They didn't have to do that for rent control property. I don't know why, but this new provision of the law, AB 1796, eliminates that. Now landlords have to provide electric vehicle charging stations, even in rent control areas. The law about 3-day notices and response to unlawful detainer summons and complaints have changed. The existing law, if you give somebody a 3-day notice, that time clock starts ticking and it goes right through weekends, right through holidays. It doesn't stop. They changed that now, so the tenant has a little bit more protection. 3-day notices don't include Saturday or Sunday or recognized holidays. So under old law, you give somebody a 3-day notice on Thursday, the time clock would run, and by Monday morning, you could file your unlawful detainer summons and complaint. Now, if you do it on Thursday, the Saturday and Sunday don't work, so you're going to have to wait through Tuesday to be able to consider that time limit to have lapsed. It also, for any of you who have evicted people before, you know there's a real short time clock on an unlawful detainer summons. Normal civil lawsuit, the defendant has 30 days to respond by filing an answer or something else. In evictions, they have 5 days to respond. That's a real short time frame. Again, that always included Saturdays and Sundays and holidays. It didn't matter. That's been changed now, so 5 days to respond to an unlawful detainer summons and complaint doesn't include weekends and holidays. There's a law on the books effective this year with regard to price gouging, and it's hard to believe people would do this, but I guess it's happening. In areas where there's a declared state of emergency, such as the wildfires, which have been bad up north this past year, there's a 10% maximum rental increase that a landlord can put into effect once a declared state of emergency exists. And that includes rental housing that wasn't on the market when the emergency was declared. So if you got property that was rented when a wildfire sweeps through an area like Paradise, and then that property becomes vacant, you're still subject to the 10% maximum increase. And they tried to anticipate some loopholes in how people would try to get around that in this law. So in addition to the basic rule, it's also illegal to evict somebody if you turn around and rent that property out to somebody else at a higher rent. Illegal to evict without cause, I should say. If they're not paying their rent, certainly you can evict them. But if you just have a situation where somebody's on a month-to-month tenancy and you have the right to give them a 30 or 60-day notice to get them out, you can't do that and then offer the property at a much higher rent. A couple of exceptions: you can have a greater than 10% rental price increase if it's directly attributable to cost of repair. And one other thing to keep in mind is that this is not county specific. So you could have, if you had a wildfire that's really bad, let's say in Riverside County, but it was significant enough that it actually had an impact on the rental housing market in Los Angeles County, landlords in Los Angeles County are going to be subject to these same limitations. Rent from third parties. How many of you guys who own property have ever had a situation where somebody you don't know comes and offers to pay the rent or makes a deposit up front or something? That's always kind of a nervous situation because nobody likes to be accepting money from people they don't know for fear that it will create a relationship with that person they don't want to have. So unfortunately, there's a new law in the books, Assembly Bill 2219, that says landlords must take checks from third parties if they're offered. If the law confirms that will not create it, by itself will not create a tenancy, it's still going to create all kinds of havoc. It's going to raise all kinds of, give people who are less than honest all kinds of crazy arguments to make to cause problems for landlords. Landlords can condition their acceptance of a third-party check on a signed acknowledgement that no tenancy is created. And fortunately, it doesn't diminish a landlord's right to terminate a tenancy for non-payment. It also doesn't obligate a landlord to accept rent after expiration of a 3-day notice period. If I've got a landlord I represent, they've had a problem tenant, and that tenant didn't pay their rent, we give them a 3-day notice, and that 3 days has come and gone, my advice to the client's going to be don't take their money if they offer it on the 4th or 5th day. If you want to be done with them, the 3-day notice period is run, the tenancy is over. This says, this new law, you don't have to turn around and accept now from a third party a check. The same rules apply. And California Association of Realtors, I believe, is going to be developing a form for this third party acknowledgement. They haven't yet. I think we'll probably see a draft of it maybe by the middle of this year, and possibly it'll be part of the CAR Forms library by the end of the year. A couple new things in regard to licensing. Seems pretty obvious, but now it's clear under the law that an applicant for a real estate or other professional license can't be required to disclose citizenship or immigration status, and an applicant can't be denied a professional license based on citizenship or immigration status. And that's kind of just a further extension of some laws that started to hit the books 4 or 5 years ago probably, protecting people in California from discrimination based on citizenship and immigration. Also on the topic of licensing, criminal convictions is a good way to not be able to get a license. If you apply for a license and you've got a really bad felony in your history, there's a good chance the Department of Real Estate is going to deny you a license. This imposes some limitations on that. It put into effect a 7-year look-back rule. So according to this law, basically a crime that was committed more than 7 years ago isn't going to be the basis for denial of a license. There's exceptions to that: financial crimes, serious felonies, crimes requiring sex offender registration. Those don't have a 7-year look-back period. Also interesting, the 7-year clock doesn't start to run until an incarcerated person has been released from prison. So some guy can't be sitting in prison studying for the real estate license exam for 7 or 8 years and get out, says, I'm ready to go. That 7-year period is going to start, so the department can still deny them a license. If you've ever had a situation, if your license comes up for renewal or something, and you've had some scrape with the law, or it wouldn't be anybody in this room, if you know somebody who's had that kind of a problem, it's really important that you disclose whatever information you've got, because the department will not only deny your application for renewal, but they'll come after it and try to revoke your license if you have submitted any kind of an application that fails to disclose a run-in you've had with the law. And I wouldn't try to, I don't know what exactly the threshold is between serious misdemeanors and felonies and all that kind of stuff. The prudent thing to do would be to disclose anything that's happened on any kind of a renewal application, so they don't use that as an independent basis for denying you or revoking your license. There's a couple new things with regard to common interest developments. The existing law was that homeowners association boards had to review financial information and reserves on a quarterly basis. That's now required on a monthly basis. So the legislature really wants to crack down on, I guess, what they perceive as problems with the finances of homeowners associations. Also, homeowners associations now have to maintain fidelity bond coverage for their directors, officers, and employees in a pretty significant amount, equal to or more than the combined amount of all HOA reserves and the total assessments for 3 months. And the managing agent of an HOA is prohibited from transferring, another type of transferring, use an N in there. Anyway, they're prohibited from transferring bank trust funds greater than $10,000 or 5% of the HOA's total combined reserve without written board approval. So that, I guess, protects from a renegade HOA manager from cleaning out an association's accounts and taking off. One of the interesting things in the law is that even though you guys as real estate brokers and salespersons are so heavily regulated, management of HOAs is relatively unregulated, and you don't have to have a specific license to be a manager of a homeowners association. There are industry groups that will certify you as a homeowners association manager, but it's not a required license. Revocable transfer, how are we doing on time? When do we need to? Are we about there? Or let me wrap up real quickly. Revocable transfer on death deeds, have any of you seen those yet? You know what that is? That's kind of an alternative to a joint tenancy deed. A revocable tenancy transfer on death deed is a deed that somebody creates that says, if I die, I want my property automatically to go to my spouse or my child or some other person. And the distinction between that and a joint tenancy deed is that it's revocable. So if the person who executes that deed changes his mind, he can go back a month later or a year later and just tear up, create a new deed that replaces it. One of the problems we see quite frequently in our office is families that are not sophisticated about their estate planning, and what they implement is they use a joint tenancy deed, putting one of their children, who they think is the most responsible child on title with them, with the understanding that that child will share with all of his siblings once mom and dad are gone. And that almost never, well, maybe just the files that cross my desk, it never happens, but it doesn't happen. the oldest son remembers, no, mom and dad wanted me to have that. He didn't plan to share it with you. So joint tenancy deed is a horrible estate planning vehicle. Don't use that, and don't if your clients want to use it, suggest they get legal advice right away about that. A couple other things real quick, then I'll wrap up and take any questions. There's a new development having to do with mediation. I mention it because mediation is really an integral part of how we resolve disputes in our industry. And there's a new law that hit the books kind of unceremoniously and unannounced at the beginning of the year that is driving my colleagues and I absolutely crazy. It requires lawyers to give this detailed disclosure to any client who's going to be in a mediation about all the limitations on how information learned in the mediation can be used. And it's got these disclosures to say, hey, even if you learn something that shows your lawyer screwed up, you can't use that to sue him. And it's just this horrible thing, and the client has to sign it. And it just, if you read it, it looks like the lawyer's admitting he's committed malpractice and wants you to say it's okay. So if you're confronted with one of those, it doesn't mean your lawyer's done a bad job or has done something wrong. It's just this new law that's required. It came out of a series of court cases over the last few years where there's some concept called the mediation privilege to encourage free exchange of ideas and settlement thoughts during mediation. There's a rule that you can't use anything that's said in mediation or any information that comes out of mediation if it doesn't settle and you end up in court. And that's a good thing. But what was happening is there were a few cases where clients came back later on, didn't like the result they got, and said, well, my lawyer gave me really bad advice during that mediation. I want to sue him. The court said, no, he gave you that bad advice in a mediation. You can't do anything about it. So as a result, as often happens, a couple of bad court decisions ends up with a overreaction by the legislature, and we've got this crazy document. So odds are one of you will, or maybe you've already seen it, but you will see something like that from your lawyer at some point, fairly soon, I imagine. PACE liens, there's a couple new things about enforceability. Legislature's cracking down on those too. They perceive there's a lot of abuse with them. So now it's unlawful to contract for work for a home improvement contract. If the property owner entered into the construction contract based on the belief that the work would be covered by the PACE program, and either they applied for and didn't get the PACE financing, or they applied for it and got it but decided to rescind during the rescission period. And then also there's a requirement that the PACE administrator verify the homeowner's ability to repay before any home improvement contract is signed. So that's a good thing. Coming soon, just a couple more things real fast. Coming soon listings. You guys know what that is, and basically it's a practice that is largely frowned upon. It's not necessarily per se illegal in all circumstances, but it's a real problem in terms of your fiduciary duties to your clients and under the MLS rules, as Brian brought to my attention recently too. Basically pocket listings. And in the most recent bulletin put out by the Department of Real Estate, the department has kind of taken a stance on that and saying, hey, we're not going to say you absolutely can't do it or that it's absolutely illegal, but we're going to caution you, don't accept any offers if you've got a coming soon listing before that property's been broadly exposed to the market, such as through the MLS, unless you've properly disclosed to your client the likelihood that they're going to get less money for their property without broad market exposure. Usually when the department sends up that kind of a flag, it's kind of like a storm warning in advance, that means they kind of decide they don't like this practice and they're going to start doing something about it. So it's kind of a good warning. It's not a good practice to engage in. And then lastly, the last thing I'm going to talk about, there is a new interactive tool for the RPA. Are you guys aware of that? It's on the CAR website. It's a fairly long presentation. It's like 128 slides explaining every single part of the residential purchase agreement. And that's a really helpful tool for you guys in terms of risk management. What you do, you download a link from the CAR website. You can provide that to your client. They can download it and review it at their leisure. Just a couple of comments on that. For it to be effective and to be a helpful tool in terms of risk management, you need to provide that link a reasonable period of time in advance of any contract being created. If you're writing an offer with somebody, with a buyer, and they have questions about the RPA, and you say, here, I'll just forward you a link, take that look at it, sign here. That's almost worse than not providing it to them in terms of risk management, because not only is it not a reasonable opportunity to learn the stuff that they should know about, it's going to suggest to some buyer's lawyer down the road that these are all the things that this buyer should have been told about, but wasn't told about in time to really fully understand what's going on. So take a look at that. It's a really good tool. Use it, but use it properly and make sure you use it with proper timing. Thank you very much.